My interest in this is, not that I love these obscure little provisions of the Constitution. It's that I love the Constitution in general. And Cato also always wants to promote people's reverence of the Constitution, not just as something that, some abstract thing that you cling to, but that you actually read the text and that we're governed by the law that's there and not by arbitrary caprice of various individuals. That being said, I think I guess I'll start with how I got involved with all this, and then go into the some more tidbits of history and structure to fill in some of the gaps that John certainly are in his article, but necessarily had to leave out of the short remarks here, and then talk about a little bit the bill that actually passed, the joint resolution, and what potential challenges could be made. I follow the Constitution and the Supreme Court for a living, so it's not like I hadn't heard of this clause or this issue, but I hadn't given it much thought until I was having a conversation right about a month ago with Gene Volokh, law professor at UCLA and the founder of the Volokh Conspiracy blog at the Federalist Society Lawyers Convention. And he was saying how some of his commenters had been tipping him off that, is this an issue? Is someone going to blog about this? What is this? And he and I and another law professor were, it's kind of like eggheads getting together in the corner of the room, talk about this emoluments clause. I mean, most people don't even know what an emolument is. I didn't fully know what it was until I read John's law review article. Then he, I guess the next, when he got back home, he blogged about it, and then the next day I cited him and piggybacked and added some more stuff, and it kind of went from there. As John says, I'm sure he's getting kind of laughs in the halls from his law partners, and I keep getting calls from media as well, and was commissioned to do a piece for the American Spectator yesterday, and all this other stuff. So there we are. What's interesting is that it's not that this issue suddenly came to the fore under the Taft administration, the first time that the Saxby fix, or what would 70 years later become known as the Saxby fix, was employed. That was with, as Tom mentioned, the nomination of a gentleman named Philander Knox to be Secretary of State in 1909, the first time the Saxby fix was implemented. I mean, the framers were aware of this, not just Madison and people when they were actually putting together the Constitution, but in the early Republic. And I'll read from Professor Paulson's article to give you a bit of background on this. Early practice adhered to this rigorous reading of the Emoluments Clause, basically the reading that John has given you. President George Washington withdrew the nomination of William Patterson of New Jersey to be an Associate Justice of the Supreme Court because Patterson had been a senator at the time the office was created, and the term for which Patterson had been elected had not expired. Washington subsequently appointed Patterson to the court, but only after his term as senator had expired. So presumably this is one of the first Supreme Courts. I mean, the court was created during that the senator's term, and Washington felt that was a disqualifying characteristic. Early Attorney General opinions confirm this rigor. The best example is an 1882 opinion holding that former Senator Kirkwood could not be appointed to a tariff commission established during the term for which he had been elected. The irony is that Kirkwood had resigned from the Senate in 1881 to become Secretary of the Interior, and that Congress had passed the act creating the office of Tariff Commissioner in 1882. After Kirkwood had left office, much as the case that John had mentioned with a congressman later on. If ever the policy thought to underlie the Emoluments Clause had no application, this was the case. Yet Attorney General Benjamin Brewster, this is in 1882 again, wrote the following: "It's unnecessary to consider the question of the policy which occasioned this constitutional prohibition. I must be controlled exclusively by the positive terms of the provision of the Constitution. The language is precise and clear, and, in my opinion, disables him from receiving the appointment. The rule is absolute, as expressed in the terms of the Constitution, and behind that I cannot go, but must accept it as it is presented regarding its application in this case." So again, until we have Secretary of State Knox, nobody seemed to doubt that this was how to apply the Emoluments Clause. I wonder whether, and John might know some of this history, how it plays in, but I wonder whether the circumvention of the Emoluments Clause under the Taft administration was kind of part of the unwinding of the Constitution generally in the Progressive Era, as it led into the Roosevelt New Deal, switch in time that saved nine, Constitutional Revolution of 1937, and so forth, into which story the nomination of Senator Black to become a justice plays in. This is a far cry, in any event, what I just read, to the change that was put in, well, first kind of without any fanfare in the Taft administration, and then under Nixon as a result of the Saturday Night Massacre, at which point, of course, Robert Bork, who had been Solicitor General, became the acting Attorney General. And his opinion, in contrast to Benjamin Brewster's in the 1880s, talked about the purpose of the constitutional provision, the rationale of the constitutional provision. This I'm quoting from his opinion. And it's ironic because, of course, Robert Bork is nothing if not the originalist, the textualist of the textualists, and here he was trying to get at intent and purpose and underlying rationale rather than the actual text of the provision. It's doubly ironic because in the Reagan administration, Bork's reading, the rejection of Bork's reading by Ed Meese and the Reagan Office of Legal Counsel led directly to Robert Bork's nomination to the Supreme Court, and ultimately the poisonous hearings and you know, ultimately what our judicial nomination confirmation process has become. Because under the Reagan administration, and I skipped the one other example under Carter of Edmund Muskie to be Secretary of State, under the Reagan administration, Orrin Hatch, then as now a senator from Utah, was the leading candidate to be a Supreme Court justice when a vacancy occurred in 1985. And he was it was better politically. He would have been much more easily confirmed than either Bork or Scalia, who had been appointed before Bork, because of senatorial privilege and collegiality. I doubt his then as now he enjoys a very good reputation among his colleagues, while still being ideologically very sound from the perspective of the Reagan administration. So even though his jurisprudence might not have been that different from Bork's, he would have been much more confirmable. So you know, because of that decision by the Reagan administration, the only administration since Howard Taft to reject the Saxby fix, Orrin Hatch is not on the Supreme Court, and Robert Bork, we have that whole saga. I should mention also with the some more tidbits from the Saxby nomination. Robert Byrd, then as now Senator from West Virginia, then as now the President pro tem of the Senate, led the charge against, such as it was, against William Saxby becoming Nixon's Attorney General, fourth Attorney General. And he said, quote, "We should not delude the American people into thinking a way can be found around the constitutional obstacle." He and 9 other Democratic senators voted against Saxby's nomination. There were only 10 votes against, including Robert Byrd. There was not a peep out of Byrd or anyone else when Muskie was appointed 7 years later, nor in Benson's case in 1993.